So there's a very interesting trademark battle happening in the news right now, now being the end of December 2025. A new company called Operation Bluebird, which is launching a social media network, has filed an application to register the trademark Twitter for that social network, media network, and has filed petitions to cancel a petition to cancel all of X's Twitter marks, including the logo and tweet and all the different uses of Twitter. And in response, so that was application and petition to cancel were filed at the beginning of December of 2025, and just a couple days ago, X filed a lawsuit against Operation Bluebird in federal court to stop Operation Bluebird from doing this. And I have reviewed both of these lengthy documents, both the petition to cancel, which is about 20 pages, and 80 pages of supporting evidence. It's very strong. And then I also took a quick look at X's complaint against Operation Bluebird, which is, both of them are actually quite salty, but particularly the X one. X, they're accusing Operation Bluebird of stealing their trademark. They're calling it a heist. There's also a lot of supporting, examples of things posted. Interestingly, Operation Bluebird its trademark lawyer used to work for Twitter, so there's some bad blood in here. But in any case, it's an interesting example of something that I have been posting about. In fact, last week's video, it was something that relates to this, slightly different flavor, and it's the issue of what is the trademark. Do the rights come from the registration or from use in commerce? And what happens when the owner of record on the USPTO is not actually using it and someone else is, who actually has the right to it? So last week I talked about what happens if someone sells a business. This happens quite often when lawyers are not involved, or at least if a lawyer is involved, if they don't understand trademarks well enough. I suppose that they might miss this issue. But the important thing to understand here is that the registration, the owner of record, is not necessarily the actual trademark owner, because trademark rights under the law come from use in commerce. And if you stop using a trademark in commerce, you lose it. It is use it or lose it. And there are a whole bunch of trademarks that are on the record showing a company like X owning the trademarks. But X made a big public deal about not using Twitter anymore. We're no longer Twitter, we're now X. They stopped all use of those logos and the word Twitter and the word tweet, and were very, very adamant about rebranding to X, which was, I would say, not necessary, and at the time I thought a pretty stupid move, and very ego-driven move. I don't know what the business argument was. Maybe they had a business argument. I hope they did. But the reason I think that was not a wise move is because those trademarks were worth a lot because of the goodwill and the recognition. But they had the choice to keep the Twitter trademarks or to rebrand. They chose to rebrand. Now they're X. And as a result, they, in my view, clearly abandoned the Twitter trademarks, making them absolutely ripe for the picking for any enterprising company that wants to pick them up and use them. Operation Bluebird has now done that. I side with them in this fight. They're going to win. X is going to lose. I'm sorry, X, but I imagine you probably have trademark lawyers who are probably telling you the same thing, and maybe your plan is to just bully them all the way to they give up. But it'll be interesting to see what happens with this. But again, this is a great example of what I call zombie trademarks, where keep in mind that because trademarks are renewed for 10-year terms, once you get to the first 10-year term, the next renewal is 10 years. And a lot can happen in that 10 years, and it's very common for trademarks to stop being used during that period, which means that the owner of record on the USPTO, that it shows as a registered trademark, but that person does not necessarily have rights. So it's one of those interesting situations. And there are companies that pick up old trademarks that have ceased to be used and start using them again. I have helped companies do this. This is very doable. This is not exotic. So anyway, I thought the example was interesting. I will be following this case, and we'll let you know how it goes. All right, thanks so much. Catherine Cavella, IP Works Law.